Hi! So in this video, we will be talking about Rule 111, Study Sesh ulit na style. Pero before we go to Rule 111, we have to discuss bar questions kasi hindi ko na-discuss yung bar questions sa previous video. Okay, so Rule 110, Prosecution of Offenses. Distinguish a complaint from information. So, na-discuss natin to. Yung pinaka-main difference ng complaint sa information is essentially parehas sila. Sworn written statement, charging a person with an offense. Tapos, subscribed by. Dito yung kinaiba. Yung sa complaint, it's subscribed by the private offended party, public officer, or peace officer in charge with the enforcement of the law. So, yun. Sa information kasi, it's subscribed by the prosecutor and is filed with the court. So, ang sabi dito is, in criminal procedure, a complaint is a sworn written statement charging a person with an offense, subscribed by the offended party, any peace officer or other peace officer charged with the enforcement of the law violated, while an information is an accusation in writing, charging a person with an offense, subscribed by the prosecutor and filed with the court. So, I guess yung isa nating dapat sinabi is statement yung complaint while charging a person with an offense, while accusation yung information in writing. Okay? So, yun din pala. And regarding sa does it have to be under oath, review lang ulit. Sa complaint, yes, it needs to be under oath. Sa information, hindi na dahil, again, by virtue of the office of the prosecutor, parang under oath na rin siya sa office niya. And may exceptions yan though. That is if private crimes, kailangan under oath yung nagsasubscribe na offended party. So, anong mga crimes to? Adultery and concubinage yung spouse, abduction, seduction, acts of lasciviousness, yung minors or yung guardian or yung parent, grandparent, guardian ng minor in that order, or kung wala, then the state on behalf of the minor at wala siyang parent, grandparent, or guardian. So, yun. While in his Nissan patrol and hurrying home to Quezon City from his work in Makati, Gary figured in a vehicular mishap along that portion of EDSA within the city of Mandaluyong. He was bumped from behind by a Ford Expedition SUV driven by Horace, who was observed using his cellular phone at the time of the collision. Okay, absorb muna natin. Okay. Both vehicles, more than 5 years old, no longer carried insurance other than the compulsory third-party liability insurance. Gary suffered physical injuries while his Nissan patrol sustained damage in excess of 500,000 pesos. This is a 2013 bar question. So the question goes, as counsel for Gary, describe the process you need to undertake starting from the point of incident if Gary would proceed criminally against Horace and identify the court with jurisdiction over the case. So, ano ba yung una nating gagawin pag vehicular accident? Okay. So, sa experience ko, kasing trabaho ko usually mga vehicular accidents sa dati kong company kasi transport industry yon. Yung unang ginagawa is of course pupunta sa police station. Mag-aano kayo doon, sinumpa ang salaysay. So, kukunin yung side ng both parties. Tapos merong traffic report or traffic investigation, parang ganon, na issue yung police station. So, may police report. Yun yung pinakaunang napoproduce yung police report. Tapos, after nung police report, after nung salaysay, I don't know, settlement muna no? Pero, gusto mo mag-proceed criminally against Horace. So, I don't know, kailangan pa bang ibaranggayan? Pag ganyan. Barangay, hindi na, no? Hindi na. So, yung gagawin nilang is mag-file. Kasi gusto mo talaga, ayaw mo pa settle eh. Usually kami nagsisettle kami. File ng complaint sa PROSEC. Kasi chartered city eh. Makati, Quezon City. Nasaan ba nangyari yung from his work in Makati, portion ed sa City of Mandaluyong. Chartered city siya, so kailangan ng preliminary investigation. So file ng complaint sa prosecutor. Tapos depende na sa prosecutor kung iti-take niya yung case. Tapos kung i-take ng prosecutor yung case, then yung prosec na yung prosec na bahala, i-file niya na yun sa court, appropriate court. So the appropriate court would be magkano yung sustained damage in excess of 500,000. RTC ba? Dahil 500,000. Magkano ba yung ay parang 2 million, no? Magkano yung damages? Hindi ko sure. Oh my gosh. 500,000. Parang 2 million yung threshold amount. Hindi ko alam kung CRIMPRO yun or yung ikakaso mo dyan kasi kung gusto mong criminal talaga, reckless imprudence resulting to damage to property. Na-injure ba siya? Yeah, meron siyang physical injuries. So, reckless imprudence resulting to physical injuries and damage to property. Yun yung magiging kaso na ipa-file ng PROSEC. Hindi ko alam kung MTC or RTC. Kung 2 million yung basis natin, MTC. Tapos, yun yung ano bang question? The certified incident would proceed. Yun yung pag-institute ng action. So the answer is, as counsel for Gary, I will first make him medically examined. Sa bagay, physical injuries. So nakalimutan natin yun. Medical examination. Tama naman para ma-assess yung physical injuries. So we missed that. So guys and girls, medical examination daw muna, which is tama naman, in order to ascertain the gravity and extent of the injuries sustained from the accident. Yup, we missed that. So tama. Second, I will secure a police report. Okay, so we got that right. Third, I will ask him to execute his sinumpaang salaysay. Yeah, nasa na rin yan. Usually una yung sinumpaang salaysay, tapos later mag-issue sa experience ko papasulatin kayo niyan yun na yung salaysay mo. Tapos parang minsan the next day pa or later pa makukuha yung police report. Then thereafter, I will use his sinumpaang salaysay or prepare a complaint affidavit and file the same in the office of the city prosecutor. So tama tayo doon. Kasi nga, Mandaluyong. So, chartered city siya, may PI. Hindi mo na kailangan i-concern yourself mo sa 4 years, 2 months, 1 day thing. And later on the appropriate MTC. Okay, so, I guess 2 million nga yung threshold. Di ako sure Pero MTC dito of Mandaluyong for the crime of reckless imprudence resulting to physical injuries and damage to property. So, tama yung crime, yung charge natin. Next question, if Gary chooses to file an independent civil action for damages, explain briefly this type of action, its legal basis, the different approaches in pursuing this type of action, the evidence you would need, and types of defenses you could expect. Mag-file ka na ng independent civil action, hindi mo i-institute sa criminal action. So, file ka ng criminal action, tapos mag-file ka rin ng civil action. Kasi magpo-proceed naman yun independently Pag hindi mo final yung separate civil action, doon siya i-hear sa criminal. So an independent civil action is an action which is entirely distinct and separate from the criminal action. Such civil action shall proceed independently of the criminal prosecution and shall require only a preponderance of evidence. Di man tinatanong yung quantum of evidence. Tinanong the evidence would need. Section 3, Rule 111. But Rule 111 na to allows for filing of an independent civil action with offended party. Wala pa kami sa Rule 111. 110 pa lang eh. Daming sinabi na. Anyway, basta yon. On his way to PNP Academy in Silang, Cavite, on board a public transport bus as a passenger, Police Inspector Masigasig of the Valenzuela Police witnessed an ongoing armed robbery while the bus was traversing Makati. His alertness and training enabled him to foil the robbery and to subdue the malefactor. He disarmed the felon and while frisking him, discovered another handgun tucked in his waist. He seized both handguns and the malefactor was later charged with separate crimes of robbery and illegal possession of firearm. Where should Police Inspector Masigasig bring the felon for criminal processing? To Silang, Cavite, where he is bound, to Makati, where the bus actually was when the felonies took place, or back to Valenzuela where he is stationed. Makati, di ba? Ano sa nangyari? Which court has jurisdiction? Of course, Makati. Diba? Na-discuss na natin. Territorial jurisdiction kung saan yung elements of the crime happened. So that's Makati. Okay. Let's check the answer. Yup. Makati. Where the felonies took place. Yvonne, a young and lonely OFW, had an intimate relationship abroad with a friend, Percy. Although Yvonne comes home to Manila every 6 months, her foreign posting still left her husband Dario lonely, so that he also engaged in his own extramarital. Kasal pala. So may kabit silang dalawa. In one particularly exhilarating session with his girlfriend, Dario died. Within 180 days from Dario's death, Yvonne gives birth in Manila to a baby boy. Irate relatives of Dario contemplate criminally charging Yvonne for adultery, and they hire a law firm to handle the case. Pero patay na si Dario eh. They don't have right. So adultery is just the offended spouse who can subscribe. So it's a question. Hindi natin yung question. Is the contemplated criminal action viable option to bring? No. Okay, so tama tayo. Answer is no. Adultery concubinage shall not be prosecuted except upon complaint by the offended spouse. Patay na eh. Is a civil action to impugn the paternity of the baby boy feasible? And if so, in what proceeding may issue be determined? Yeah, pwede. Pwede yan paternity. Pwede nga yung heirs mag-question. Pero hindi na to 110. Family code to. Huwag na natin i-discuss yan. So, X was arrested in flagrante for robbing a bank. After an investigation, he was brought before the office of the prosecutor for inquest. Yung inquest, ito yung, ano nga yung inquest? Hanapin nga natin. Para sure. Inquest. Proceeding. Na-arrest without a warrant. So, para siyang PI, pero summary. Kasi arrested without warrant. May lawful warrantless, valid warrantless arrest. He was brought before the office, but unfortunately no inquest prosecutor was available. May the bank directly file the complaint with the proper court? If in the affirmative, what document should be filed? Hindi sinabi kung anong set dito. I guess yes, kasi walang inquest prosecutor. Kaya naman hintayin nila yan. Nagra-run yung prescriptive period nila. So the answer is, yep, the bank may directly file the complaint with the proper court. In the absence or unavailability of an inquest prosecutor, the complaint may be filed with the offended party or peace officer directly with the proper court on the basis of affidavit of the offended party or arresting officer or person. Your friend YY, an orphan, 16 years old, seeks your legal advice. She tells you that ZZ, her uncle, subjected her to acts of lasciviousness. Oh no. That when she told her grandparents, they told her to keep quiet and not to file charges against ZZ, their son. Feeling very much aggrieved, she asks you how her uncle ZZ can be made to answer for herself. Just file a case, a minor can do it. Hindi capable yung minor filing case for acts of lasciviousness. What would your advice be? I would advise a minor to file a complaint herself, independently of her grandparents. She is not incompetent or incapable of doing so. Grounds other than her minority. Suppose the crime committed against YY by her uncle ZZ is rape. Pag rape, public na to, hindi to private. Ganon pa rin. Punta pa rin siya sa prosec, yung prosec ng witnessed by her mutual friend XX, but this time YY was prevailed upon by her grandparents not to file charges. XX asks you if she can initiate the complaint. Yung friend, the complaint's easy. Pwede, kasi public crime eh. Yeah, pwede. Yep, sabi dito pwede. The prosecution filed an information against Jose for slight physical injuries, alleging the acts constituting the offense, but without any more alleging that it was committed after Jose's unlawful entrance in the complainant's abode. Against Jose. Was the information correctly prepared by prosecution? Why? So if alleging, without any more alleging that it was committed after Jose's. So si Jose inflict ng slight physical injuries against the complainant. Tapos may unlawful entry rin sa bahay niya. Was information correctly prepared by the prosecution? Dapat sana in-allege niya yung unlawful entry. I mean, it wouldn't be wrong. Like, the information is still valid. It's just that, sayang lang. Hindi ma-include as an aggravating circumstance yung unlawful entry. Diba? Or pwede din trespass. Pwede din yun. So, pero wala namang mali kung yun lang yung gusto nilang ikaso, diba? Wala namang mali. Pero mas okay sana kung in-include yun. So, paano natin sasabihin, is it a yes or no? Correctly prepared? When you say correctly prepared, does it have to be like yung pinaka-correct? Or okay na? I guess, it's not incorrect din eh. It's so confusing. I would say hindi pwedeng maybe eh, or it depends, or what. Ayoko ng gano'n. Dapat yes or no. Was it correctly prepared? Yes, I think it's correctly prepared. However, it will not be complete. But there's nothing wrong with it. It's not incorrect per se. Let's check the answer. Sabi dito no daw. The aggravating circumstance of unlawful entry has to be specified in the information, otherwise it cannot be considered as aggravating. Yeah, pero di naman yung tanong yung was it correctly filed? I don't know. But sabi dito no, dapat in-allege daw yung aggravating. But the way I would answer it is that yes, it's correct, but it's incomplete. But it would still be valid. It's just that the aggravating circumstance will not be appreciated, but it will not render the information invalid. D and E were charged with homicide in one information before they could be arraigned. The prosecution moved to amend the information to exclude E therefrom. Can the court grant the motion to amend? But was this before arraignment? Yeah. Pero, because ida-downgrade mo or ibahin mo yung offenders, you have to give notice to the offended party. Diba ganun yung rule? You have to give notice to offended. Pero hindi kailangan leave of court kasi without leave of court pa rin kasi before arraignment eh. Okay. So the answer is yes, provided notice is given to the offended party and the court states its reasons for granting the same. On the facts above stated, suppose the prosecution, instead of filing a motion to amend, moved to withdraw the information altogether and its motion was granted. Can the prosecution refile the information, although this time for murder? Yeah, pwede pa. Kasi wala pa na, hindi pa naman na-arraign eh. So yeah, I think yes. Yeah, yes. The prosecution can refile the information for murder in substitution of the information for homicide. No double jeopardy has yet attached. A was accused for homicide for the killing of B. During the trial, the public prosecutor received a copy of marriage certificate of A and B. Homicide for A. Hindi yun homicide, parricide dapat. Can the public prosecutor move for the amendment of information to charge A with the crime of parricide? During trial na eh. Trial na. So, thing is, during trial na pinakita yung evidence. Hindi rin siya yung nasa information of the acts or omissions. Dapat inallege na yung qualifying circumstance. Otherwise, kung hindi inallege, hindi siya ma-appreciate. If hindi ma-appreciate yung qualifying circumstance of relationship that qualifies the crime from homicide to parricide, then it won't fly. Ang dami ng jurisprudence na ganyan. Dapat pinuprove yung relationship. Dapat ina-allege yung relationship from the very beginning. So it's just homicide, unfortunately. So yeah, no, the information cannot be amended to change the offense charged from homicide to parricide. The marriage is not a supervening fact arising from the act constituting charge of homicide. At saka trial na eh. Trial na. Na yun, substantial amendment na yan eh. Bawal na yan. Dapat formal amendments na nga lang with leave of court eh. Suppose instead of moving for the amendment of information, the public prosecutor presented in evidence marriage certificate without objection on the part of the defense. Could A be convicted of crime? Hindi pa rin. Hindi pa rin. Kasi hindi mo siya nilagay sa information mo na okay sana kung homicide yung title ng charge na nilagay mo. Pero nilagay mo dun sa pinaka-information pa lang na married sila. Parang yung acts constituting the offense, describe mo na parricide talaga siya. Then, okay lang. Pero kasi, saka mo lang inano nung ano na eh. So, kahit walang objection, bawal. So, no, A cannot be convicted. No, A can be convicted only of homicide and not of parricide, which is a graver offense. The accused has constitutional rights of due process to be informed of the nature and the cause of the accusation against him. Yeah. So, yun yung bar cues for Rule 110. Okay. So, papahinga muna ako and then we'll go to Rule 111. Same thing. We're gonna read Codal, Rule 111, and then we will discuss the concepts pa isa-isa based on the Bar Syllabus. 1, 2, 3, 4, 5, lima. Lima yung topics for Rule 101. Implied institution of civil action arising from crime, prior reservation, suspension, waiver of civil actions, independent civil actions, civil liability ex delicto in cases of acquittal and death of accused, and prejudicial question. Okay, so reading time ulit tayo na ang codal. So, Rule 111. So, Rule 111, Prosecution of Civil Action. Section 1, Institution of Criminal and Civil Actions. When a criminal action is instituted, the civil action for the recovery of civil liability arising from the offense charged shall be deemed instituted with the criminal action unless the offended party waives the civil action, reserves the right to institute it separately, or institutes the civil action prior to the criminal action. The reservation of the right to institute separately the civil action shall be made before the prosecution starts presenting its evidence and under circumstances affording the offended party a reasonable opportunity to make such reservation. When the offended party seeks to enforce civil liability against the accused by way of moral, nominate, temporate, or exemplary damages without specifying the amount thereof in the complaint or information, the filing fees, therefore, shall constitute a first lien on the judgment awarding such damages. Where the amount of damages other than actual is specified in the complaint or information, the corresponding filing fees shall be paid by the offended party upon the filing thereof in court. Except as otherwise provided in these rules, no filing fees shall be required for actual damages. No counterclaim, cross-claim, or third-party complaint may be filed by the accused in the criminal case, but any cause of action which could have been the subject thereof may be litigated in a separate civil action. The criminal action for violation of Batas Pambansa Bilang 22 shall be deemed to include the corresponding civil action. No reservation to file such civil action separately shall be allowed. Upon filing of the aforesaid joint criminal and civil actions, the offended party shall pay in full the filing fees based on the amount of the check involved, which shall be considered as the actual damages claimed. Where the complaint or information also seeks to recover liquidated, moral, nominal, temporate, or exemplary damages, the offended party shall pay the filing fees based on the amounts alleged therein. If the amounts are not so alleged, but any of these damages are subsequently awarded by the court, the filing fees based on the amount awarded shall constitute a first lien on the judgment. Where the civil action has been filed separately and trial thereof has not yet commenced, it may be consolidated with the criminal action upon application with the court trying the latter case. If the application is granted, the trial of both actions shall proceed in accordance with Section 2 of this rule governing consolidation of the civil and criminal actions. Section 2. When separate civil action is suspended. After the criminal action has been commenced, the separate civil action arising therefrom cannot be instituted until final judgment has been entered in the criminal action. If the criminal action is filed after the said civil action has already been instituted, the latter shall be suspended in whatever stage it may be found, before judgment on the merits. The suspension shall last until final judgment is rendered in the criminal action. Nevertheless, before judgment on the merits is rendered in the civil action, the same may, upon motion of the offended party, be consolidated with the criminal action in the court trying the criminal action. In case of consolidation, the evidence already adduced in the civil action shall be deemed automatically reproduced in the criminal action without prejudice to the right of the prosecution to cross-examine the witnesses presented by the offended party in the criminal case and of the parties to present additional evidence. The consolidated criminal and civil actions shall be tried and decided jointly. During the pendency of the criminal action, the running of the period of prescription of the civil action, which cannot be instituted separately or whose proceeding has been suspended, shall be tolled. The extinction of the penal action does not carry with it extinction of the civil action. However, the civil action based on delict may be deemed extinguished if there is a finding and a final judgment in the criminal action that the act or omission from the civil liability may arise did not exist. Section 3. When civil action may proceed independently. In the cases provided in Articles 32, 33, 34, and 2176 of the Civil Code of the Philippines, the independent civil action may be brought by the offended party. It shall proceed independently of the criminal action and shall require only a preponderance of evidence. In no case, however, may the offended party recover damages twice for the same act or omission charged in the criminal action. Section 4. Effect of death on civil actions. The death of the accused after arraignment and during the pendency of the criminal action shall extinguish the civil liability arising from the delict. However, the independent civil action instituted under Section 3 of this rule, or which thereafter is instituted to enforce liability arising from other sources of obligation, may be continued against the estate or legal representative of the accused after proper substitution or against said estate, as the case may be. The heirs of the accused may be substituted for the deceased without requiring the appointment of an executor or administrator, and the court may appoint a guardian ad litem for the minor heirs. The court shall forthwith order said legal representative or representatives to appear and be substituted within a period of 30 days from notice. A final judgment entered in favor of the offended party shall be enforced in the manner especially provided in these rules for prosecuting claims against the estate of the deceased. If the accused dies before arraignment, the case shall be dismissed without prejudice to any civil action the offended party may file against the estate of the deceased. Section 5. Judgment in civil action not a bar. A final judgment rendered in a civil action absolving the defendant from civil liability is not a bar to a criminal action against the defendant for the same act or omission subject of the civil action. Section 6. Suspension by reason of prejudicial question. A petition for suspension of the criminal action based upon the pendency of a prejudicial question in a civil action may be filed in the office of the prosecutor or the court conducting the preliminary investigation. When the criminal action has been filed in court for trial, the petition to suspend shall be filed in the same criminal action at any time before the prosecution rests. Section 7. Elements of prejudicial question. The elements of a prejudicial question are: first, the previously instituted civil action involves an issue similar or intimately related to the issue raised in the subsequent criminal action. And lastly, that the resolution of such issue determines whether or not the criminal action may proceed. So that's Rule 111. Okay, so I'll rest for a bit and then we will start discussion for Rule 111. So again, we have 5 topics. Alright, so let's talk about Rule 111, prosecution of civil actions. So, as a general rule, when a criminal action is instituted, the civil action for the recovery of civil liability arising from the offense shall be deemed instituted with the criminal action. You don't have to do anything. But there are exceptions. That is, when the offended party waives the civil action, when the offended party reserves his right to institute a separate civil action, gusto niyang itry sa separate civil action. Why? Because sa criminal action, yung quantum of evidence is proof beyond reasonable doubt. It's the highest quantum of evidence requirement. Whereas, if civil case lang, it's just preponderance of evidence. So, pwedeng manalo ka pa rin sa civil case even if hindi ka manalo sa criminal case. And when the offended party institutes a civil action prior to the criminal action, which could also happen. So, the filing of a civil action for arising from a delict is not a bar for a subsequent criminal action. Hindi ibig sabihin na nag-file ka na ng civil action, ay bawal ka nang mag-file ng criminal action against me. No. Kasi magkaiba sila. It's just that kung na-file mo na yung civil action, hindi mo na siya i-file, hindi na siya deemed included or instituted dun sa criminal action. Why? Kasi parang doble yung nakuha mo, diba? That's unjust. Eh, hindi ka naman supposedly mag-profit from a case, diba? From filing a case. Under Section 1 of Rule 111, only civil liability arising from the crime charged is deemed instituted. Kasi diba, when one commits a crime, for example, usually there's injury or damage. So when there's injury or damage, there is of course civil liability. Hence, civil actions under the Civil Code, specifically Articles 32, 33, 34, and 2176, remain separate, distinct, and independent of any criminal prosecution, although based on the same act. So, ano ba tong 32, 33, 34, and 2176? Tignan nga natin. So, yung 32, constitutional or civil rights. Yung 33, basahin na nga lang natin yung New Civil Code Article 32. Moral damages, yung 32. Check natin. 32. Any public officer or employee or any private individual who directly or indirectly obstructs, defeats, violates, or in any manner impedes or impairs any of the following rights or liberties of another person shall be liable to the latter for damages. So ito yung mga freedom of religion, freedom of speech, freedom to write for press or maintain a periodical publication, freedom from arbitrary or illegal detention, freedom of suffrage, right against yung mga constitutional rights. So, pwedeng damages. That's 32. 33 is in case of defamation, fraud, and physical injuries. a civil action for damages entirely separate and distinct from the criminal action may be brought by the injured party. Such civil action shall proceed independently of the criminal prosecution and shall require only preponderance of evidence. 34 naman, when a member or city municipal police force refuses or fails to render aid or protection to any person in case of danger to life or property, such peace officer shall be primarily liable for damages and the city or municipality shall be subsidiarily responsible therefore. The civil action herein recognized shall be independent of any criminal proceedings and the preponderance of evidence shall be sufficient to support such action. So, yun. And there's another one. It's 2176. So, tingnan natin. 2176. Whoever by act or omission causes damage to another, there being fault or negligence, is obliged to pay for damage done. So this is torts. Yeah. This is torts, basically. Quasi-delict. Yan. So, yun. Independent civil action. When reservation of the right to institute civil action separately shall be made before the prosecution starts to present his evidence and under circumstances affording the offended party a reasonable opportunity to make such reservation. Purpose: the same is intended to prevent double recovery from the same act or omission. The appearance of the offended party in the criminal case through a private prosecutor may not per se be considered either as an implied election to have his claim for damages determined in said proceedings or a waiver of his right to have it determined separately. Okay. So yes, there's a prohibition double recovery. The judgment of the court must state civil liability or damages to be recovered by the offended party, if any, except when enforcement of a civil liability, a separate civil action has been reserved or waived. So, effect of reservation of right: the prescriptive period of the civil action that was reserved shall be tolled. So, when reservation to file separately not allowed, BB22 cases. Kasi deemed instituted eh. Cases cognizable by the Sandigan Bayan, tax cases. In such cases, only the civil liability arising from the crime charged, cause of action arising from the delict is deemed instituted. Okay. So, what are the rules on filing fees when civil action is deemed instituted? Natin yung Bar Syllabus muna. Okay, so na-cover na natin implied institution of prior reservations. Okay. So, tuloy lang natin. No filing fees are required for amounts of actual damages except with respect to criminal actions for violation of BP22, in which case the offended party shall pay in full the filing fees based on the face value of the check as actual damages. So the reason for this exception is that the dockets of courts are clogged with BP22 cases since creditors virtually use the courts as collectors. Because ordinarily, no filing fee is charged in criminal cases for actual damages. So the payee uses intimidating effect of the criminal charge to collect his credit gratis, and sometimes upon being paid, the trial court is not even informed thereof. So kaya meron ng filing fees for actual damages, walang filing fees except for BP22 cases kasi nga parang ginagawang collector si court to intimidate debtors. So, kailangan bayaran yung full face value of the check as actual damages. In estafa cases, the filing fees shall be paid based on the amount involved. However, where the plaintiff has paid the amount of filing fees assessed by the clerk of court and the amount turned out to be deficient, the trial court still acquires jurisdiction over the case subject to the payment by the plaintiff of the deficiency assessment. Where the amount of damages other than actual, moral, exemplary, and other damages is specified in the complaint or information, the corresponding filing fees shall be paid by the offended party upon filing thereof in court, and where the offended party seeks to enforce civil liability against the accused by way of moral, nominal, temperate, or exemplary damages without specifying the amount thereof in the complaint or information, the grant and amount thereof are left to the sound discretion of the trial court. The filing fees thereof shall constitute a first lien on the judgment awarding such damages. So, payment of filing fees and jurisdiction, a court acquires jurisdiction over any case only upon payment of the prescribed docket fee. But where the plaintiff has paid the amount of filing fees assessed by the clerk of court and the amount turned out to be deficient, the trial court still acquires jurisdiction over the case, subject to the payment by the plaintiff of the deficiency assessment. To penalize a party for the omission of the clerk of court is not fair if the party has acted in good faith. Counterclaims, cross-claims, third-party complaints are not allowed in a criminal proceeding. Any claim which could not have been the subject thereof may be litigated in a separate civil action. The counterclaim of the accused will unnecessarily complicate and confuse the criminal proceedings, and the trial court should confine itself to the criminal aspect and the possible civil liability of the accused arising out of the crime. In an appeal of a criminal case, the appellate court may impose additional damages or increase or decrease the amounts of damages upon the accused appellant. However, additional penalties cannot be imposed upon a co-accused who did not appeal, but modifications of the judgment beneficial to him are considered in his favor. So, compromise in civil aspect. The offended party may compromise the civil aspect of a crime. That's allowed, provided that it must be entered before or during litigation and not after final judgment. So, pwedeng until trial. A compromise in the civil aspect is valid even if it turns out to be unsatisfactorily either to one or both of the parties. Settlement, nag-agree sa compromise. Criminal liability for estafa is not affected by compromise or novation of contract, for it is a public offense which must be prosecuted and punished by the government on its own motion, even though complete reparation should have been made of the damage suffered by the offended party. Okay. So, ano pa yung pwede nating sabihin about the topic? When the accused unexpectedly pleaded guilty to the offense charged during the arraignment, the offended party should still be afforded a reasonable time therefrom to make reservation or to present evidence to prove civil damages. So this is Reyes versus Sempio D case. Does the question of the penal action carry with it extinction of civil action? No. Okay, however, civil action based on delict may be deemed extinguished if there is a finding in the final judgment the criminal action, the act or omission from which a civil liability may arise did not exist. So, ano pa? Okay. So now let's talk about when separate civil action is suspended. Well, before that, separate action filed by the accused, no counterclaim, cross-claim, or third-party complaint may be filed by the accused in the criminal case. But any cause of action which could have been the subject thereof may be litigated in a separate civil action. So, important to remember that the accused, kung gusto nyo mag-counterclaim, cross-claim, or third-party complaint, dapat separate, not sa criminal action, so as not to confuse, diba? So, when separate civil action is suspended. So, when the civil action is filed before the criminal action, as a general rule, if the civil action is instituted before the institution of the criminal action, such pending civil action in whatever stage is found shall be suspended until final judgment of the criminal action has been rendered. So again, sinabi ko kanina, kapag nag-institute ng civil action, hindi siya bar to file a criminal action if that civil action arises from that delict. Yung mangyayari sa civil action is suspend muna and then bibigyan ng priority in criminal action. Why? Because the civil liability nga arises from the criminal action. So, kailangan mo nang i-determine kung may criminal action nga ba. So, in a way, kailangan i-resolve to para malaman kung entitled ka dito. Like, it helps, diba? The exception is in cases of independent civil actions, in cases where civil action presents a prejudicial question. So, pag yung civil action prejudicial question naman is, kailangan mo munang i-answer tong prejudicial question para ma-resolve mo tong criminal case. Diba? Parang ganun lang din eh. As a general rule, parang yung criminal action yung nagiging prejudicial question. Yung kailangan mo munang sagutin para mas ma-resolve mo to. Kasi, pag na-solve mo na to, pag may resolution na dito, diba, alam mong entitled ka dito. Although, iba yung quantum of evidence, it really depends. It doesn't necessarily follow. Kapag ka prejudicial question naman, hindi siya masususpend kasi kailangan mo nang i-resolve to para mas makakome up ka ng fair judgment dito sa criminal action. So, ganun lang yung reason nun. Where the civil action is not one intended to enforce civil liability arising from the offense. So, that's also an exception because paring tuloy pa rin to kasi independent eh. Hindi mo kailangan i-resolve to para dito. So, the only reason why you have to suspend this civil action and give priority to the criminal action is para because this arises from criminal action eh. But in situations that it doesn't, that you have to resolve this, and you have to resolve this first, that's an exception. Rules preclude a motu proprio suspension by the judge of the civil action. It must be by petition of the defendant. So, walang motu proprio suspension, dapat by motion. Consolidation of civil with criminal action. Before judgment on the merits is rendered in the civil action, such may be consolidated with the criminal action and the court trying the criminal action upon motion of the offended party. The evidence already adduced in the civil action will be automatically reproduced in the criminal action. There can also be no motu proprio consolidation. It must be upon the motion of the offended party. Yung suspension upon the motion of the defendant, the accused, or yung defendant. Kasi plaintiff yun yung complainant eh. Sa consolidation must be upon the motion of the offended party. It just makes sense, diba? When criminal action filed before, after the criminal action has been commenced, the separate civil action arising therefrom cannot be instituted until final judgment has been entered in the criminal action. Tuloy lang. So, yung kailangan lang tandaan is the criminal action takes precedence. Okay. So, effect of death of the accused or convicted on civil action. So, civil liability ex delicto. In cases of acquittal, in cases of death. So, unahin natin yung death. Before arraignment, the criminal case shall be dismissed without prejudice to any civil action that the offended party may file against the estate of the deceased. So, pwede pa rin mag-continue yung civil aspect and i-charge siya sa estate. But the criminal liability is of course extinguished. Wala na eh. After arraignment and during pendency of the criminal action, yung sabi na dismissed without prejudice, meaning you can file it Okay, you can file it again. Pagka after arraignment and during pendency of the criminal action na, the civil liability is extinguished. But an independent civil action enforcing liabilities under 32, 33, 34, 35, and 2176. So again, under 32, violation, damages, violation ng constitutional rights. Yung 33, hindi ko alam kung in order to basta yung isa violation ng constitutional rights, yung isa, yung 2176, yung quasi-delict, yung, hindi ko alam kung 33, 34, 35, yung police officer na hindi nga ginawa yung trabaho niya, hindi siya tumulong, what else? Pag arising from physical injuries, fraud, and defamation, yun. Baka may na-miss ako pero yun. May be continued against the estate or legal representative of the accused after proper substitution. If the civil action has been reserved and subsequently filed, the civil action shall proceed after substitution of the parties. So, isa-substitute mo kasi wala na nga yung akusado, namatay na nga. Diba? So, yung heirs, yung estate, yung representative. During appeal naman, civil and criminal liabilities are extinguished. Only civil liability ex delicto is extinguished. So, again, yung civil liability na naka-attach dun sa crime. Kasi, hindi na itutuloy yung, wala nang criminal liability, so therefore, wala civil liability. Unless a separate civil action may be instituted based on other sources of civil liability, not the delict. After judgment, the civil liability is not extinguished. Wala na kasi prior judgment, merong benefit of a doubt, merong presumption of innocence of the accused. That's why yung pwede mo lang i-pursue is yung civil action na hindi connected dun sa delict, not arising from the delict. But after judgment and there's like a conviction, then the guilt of the accused is already determined. It's already found to be existing, and therefore guilty nga siya and proven beyond reasonable doubt na. So the attaching civil liability will subsist and will be charged dun sa estate. It's not extinguished. Claims shall be filed against the estate of the accused. So, paano naman kapag yan yung death, acquittal. Okay? Pag acquittal, wala na diba? Wala na kapag arising from delict. Di ko mahanap. Wala na pag arising from, i-double check nyo na lang. Pero para sa akin, wala na kasi acquitted na Unless na lang yung civil action is arising from other sources na hindi dun sa delict. So, nakalagay dito sa syllabus C, Civil Code Article 29. Yan natin yan. Article 29. When the accused in a criminal prosecution is acquitted on the ground that the guilt has not been proved beyond reasonable doubt, a civil action for damages for the same may be instituted daw. Such action requires only a preponderance of evidence. Upon motion of the defendant, the court may require plaintiff to file a bond. Okay. And if in a criminal case, judgment is based upon reasonable doubt. Pwede pala. Sorry, mali ako. So, kapag acquittal, pwede pa rin mag-file ng civil action kasi baka preponderance of evidence lang That is if it's on the ground that the guilt has not been proved beyond reasonable doubt. Pwede kasing hindi niya na-reach yung proof beyond reasonable doubt pero kaya namang ma-reach yung preponderance of evidence. Okay. So, important yun. Okay. Article 29. Okay, good. Good na chinek natin. Nasa syllabus din eh. And the last topic for Rule 111 is prejudicial question. In fairness, may kilang Rule 111. What is a prejudicial question? One which arises in a case where the resolution of which is a logical antecedent of the issue involved therein, and the cognizance of which pertains to another tribunal. There is a prejudicial question only when the matter has to be priorly decided by another authority, is the one where the cognizance of which pertains to the authority and should not, under the circumstances, be passed upon by the court trying the criminal case. It is a question based on fact, distinct and separate from the crime, but so intimately connected that it determines the guilt or innocence of the accused. So, if both civil and criminal cases have similar issues, or the issue is one intimately related to the issues raised in another, then a prejudicial question would likely exist, provided the other element or characteristic is satisfied. It must appear not only that the civil case involves the same facts upon which the criminal prosecution would be based, but also that the resolution of the issues raised in the civil action would be necessarily determinative of the guilt or innocence of the accused. That is to avoid two conflicting decisions in the civil case and the criminal case. So what are the elements of a prejudicial question? First, the civil action must be instituted prior to the criminal action. It involves an issue similar or intimately related to the issue raised in the subsequent criminal action. The resolution of such issue determines whether or not the criminal action may proceed, and jurisdiction to try said question must be lodged in another tribunal. Again, civil action must be instituted prior to the criminal action. It involves an issue that is similar or intimately related to the subsequent criminal action, and the resolution of such issue determines whether or not the criminal action may proceed. Kaya nga i-resolve mo siya early. Kasi pag na-resolve mo siya early, na-answer mo muna to, dun mo malalaman kung kailangan mo pa ba ng criminal action. So kailangan mong i-resolve muna tong prejudicial question. Jurisdiction to try said question must be lodged in another tribunal. Again, this prejudicial question is not determinative of the guilt. It just resolves some questions so that the criminal action may proceed smoothly. So, the effect is suspension of criminal action. Kasi kailangan mo nang i-resolve to eh. It does not prescribe the dismissal of the criminal action, however. A prejudicial question cannot be appreciated where the subject actions are all civil in nature. Malamang. Test to determine the existence of prejudicial question. To determine the existence of a prejudicial question, it must appear that the civil case does not only involve the same facts upon which the criminal prosecution is based, but also that the resolution of the issues raised in said civil action would necessarily be determinative of the guilt or innocence of the accused. So, hindi lang pala siya clarify lang. Hindi lang pala siya kailangang i-resolve lang for certain matters. Kailangan mo siya i-resolve kasi parang dun mo malalaman kung kailangan pa ng criminal action. Pero again, hindi siya determinative of guilt ha. Kasi, hindi naman criminal yung civil action. It just answers some questions so that you know whether or not to proceed na with the criminal action. There is a possibility na guilty, pero there is also a possibility na hindi na. And if parang malabo na talagang ginawa kapag na-resolve yung prejudicial question, pag malabo na talaga that there's a crime committed, then hindi na matutuloy yung criminal action. Good thing, di ba? Pero kapag hindi, may possibility na may crime committed, may possibility na wala, which is fully threshed in a full-blown criminal case. So, when to file petition for suspension by reason of a prejudicial question during preliminary investigation or in court at any time before the prosecution rests its case. So, before matapos yung presentation ng evidence ng prosecution, usually prosecution na una eh. Tapos defense. Unless nilang baliktad, like self-defense. So, where to file petition for suspension by reason of prejudicial question? The office of the prosecutor, or kapag umabot na sa court, then court where the criminal action has been filed for trial at any time before the prosecution rests its case. So, examples of those not considered as prejudicial question: nullification of marriage under Article 36 is not a prejudicial question in a criminal case for first rate and parricide. Why? Kasi ground mo Article 36, which is psychological incapacity. However, if nullification of marriage is due to another ground, a different ground, not psychological incapacity, then it's possible that it's a prejudicial question kasi importante if parricide nga o hindi. Syempre, mas malaki yung penalty for parricide kumpara sa homicide or kumpara sa homicide lang. So, para maging parricide, kailangan mag-asawa. So, kailangan muna i-answer yung question if mag-asawa nga ba sila para alam natin kung tama yung parricide. Baka naman iba. Baka hindi naman parricide. Rescission of a contract of sale is not a prejudicial question to BP22 case. Why? Simple. Wala yun sa elements ng BP22 eh. Kasi, yung BP22, mere issuance of a check. Wala namang kahit by virtue of a contract pa yan. It's mala prohibita. Independent civil action based on fraud will not raise a prejudicial question to stop proceedings in a pending criminal prosecution for estafa through falsification. Civil case on garnishment of funds, not prejudicial question to BP22 case. Same concept. It's the mere issuance of a bouncing check. So that's it for Rule 111 discussion. I will just rest for a bit and then we will bar cues. Okay, so mag-bar cues na tayo. Name 2 instances where the trial court can hold the accused civilly liable even if he is acquitted. Independent civil action. Yun yung una kong naisip. Tapos, ano ba? Yung sinabi ko kanina, acquittal is based on reasonable doubt. Instances. If the source of the civil liability is not the delict, diba? Other sources. Yun. Ano sabi ko? If independent civil action, if yung based on reasonable doubt, kasi preponderance of evidence lang yung kailangan, and if other sources. So the answer is where the acquittal is based on reasonable doubt. So we got 1. Where the court expressly declares that the liability of the accused is not criminal but only civil in nature. So we didn't get that one. So pwede pala yun, that the court will just declare that there's no criminal liability. They're just, okay, yeah, we've read decisions like that, no? That acquitted but there is civil liability. So okay, we missed that one. Where the civil liability is not derived from or based from the criminal act of which, derived from other sources. Wala dito yung sabi kong independent civil action. Because, it's not responsive to the question. Not extended despite the acquittal of the accused. Anyway, so that's the first question. Next, Tomas was criminally charged with serious physical injuries allegedly committed against Darwin. During the pendency of the criminal case, Darwin filed a separate civil action for damages based on the injuries he had sustained. Yeah, independent civil action kasi yung injuries, diba? Kasama yon sa, yung 32 to 34, ewan ko kung alin siya doon. Tomas filed a motion to dismiss the separate civil action on the ground of litispendentia na pointing out that when the criminal action was filed against him, the civil action to recover the civil liability from the offense charge was also deemed instituted. Na he insisted that the basis of separate civil action was the very same act that gave rise to the criminal action. Rule on Thomas' motion to dismiss with brief reasons. Thomas' motion to dismiss on the ground that he said is unmeritorious kasi nga it's one of the exceptions, diba? That an independent civil action may be filed in case of physical injuries, such as in this case. So the answer here is Tomas' motion to dismiss on ground of litispendentia should be denied. In cases of physical injuries, the civil action for damages entirely separate and distinct from the criminal action may be brought by the injured party. Such civil action shall proceed independently of the criminal action and hence may not be dismissed on the ground of litispendentia. So yeah, you got that one right. While cruising on a highway, a taxi cab driven by Mans hit an electric post. As a result thereof, its passenger Jovi suffered serious injuries. Mans was subsequently charged before the MTC with reckless imprudence resulting in serious physical injuries. Thereafter, Jovi filed a civil action against Lourdes, the owner of the taxi cab, for breach of contract of carriage, and Mans for quasi-delict. Lourdes and Mans filed a motion to dismiss and civil action on the ground of litispendentia na injuries So, separate ulit, pwede ulit, exception. That is, the pendency of civil action, resolve the motion with reasons. Same lang sa previous question. So, yung same lang yung answer, essentially. So, the motion to dismiss should be denied. The action for breach of contract against a taxi cab owner cannot be barred by the criminal action. Yeah, civil yun On the other hand, civil action for quasi-delict, independent civil under Article 33. Okay. Pero kailangan din natin explain na yung liability ng, parang 2176 yun damages. Pero basta torts yan, diba, na, or registered owner rule, or contract of carriage. Oh my God, I don't know what I'm talking about. Pero, basta yun. In an action for violation of Batas Pambansa bilang 22, the court granted the accused's demurrer to evidence which he filed without leave of court. Although he was acquitted of the crime charged, he, however, was required by the court to pay the private complainant the face value of the check. The accused filed a motion for his consideration regarding the order to pay the face value of the check on following grounds. The demurrer to evidence applied only in the criminal aspect of the case. No, BB22 kasi, di ba? Civil and criminal aspect combined. So the answer is the motion for consideration should be denied. The ground that the murder evidence applied only to the criminal aspect of the case was not correct. This criminal action for BB22 included corresponding civil action. Yes, combined. At the very least, he was entitled to adduce controverting evidence on civil liability. Solve motion for consideration. No na. The accused was not entitled to adduce controverting evidence on civil liability because he filed his demurrer to evidence without leave of court. Prejudicial question. Solomon and Faith got married in 2005. In 2010, Solomon contracted a second marriage with Hope. When Faith found out about the second marriage of Solomon, she filed a criminal case for bigamy, RTC of Manila, in 2011. Meanwhile, Solomon filed a petition for declaration of nullity of his first marriage with Faith in 2012, while the case for bigamy before RTC of Manila is ongoing. Subsequently, Solomon filed a motion to suspend the proceeding in bigamy case on prejudicial question. Pwede. He asserts that the proceedings in the criminal case should be suspended because if his first marriage with Faith will be declared null and void, it will have the effect of exculpating him from the crime of bigamy. Decide. Yeah, pwede. I think it constitutes as a prejudicial question. Kasi if hindi niya naman asawa, then walang standing si wife na mag-file for bigamy. So the answer is the motion filed by Solomon should be denied. Oh, so mali ako. The elements of prejudicial question are the previous incident civil action involves an issue similar or intimately related and to the issues determines the subsequent criminal action and resolution of such issue. Okay. Bakit though? Since a criminal case for bigamy was filed ahead of the civil action for the there is no okay. So, para mag-prejudicial question, dapat talaga pala, nauna talaga si civil case. Okay? Di ko naintindihan yun ng maayos. So, again, prejudicial question lang siya na kayang mag-suspend ng criminal proceedings if nauna si civil. So, hindi ka pala pwedeng mag-file ng civil para ito i-suspend yung criminal. Pwede mo lang ma-suspend yung criminal if may ongoing kang civil or naunang civil. Okay. You know, we learn new things. That's why we review. Doesn't mean that we know everything already. It's good. This is good. And okay. The inherent outcome of civil case for annulment has no bearing upon the determination of guilt or innocence of the accused for bigamy because the accused has already committed crime of bigamy when he corrected without first okay, kailangan ng judicial declaration of nullity. Yun din Yun din yung isa ko iniisip kung guilty na ba siya agad kasi at that time na nag-commit siya ng bigamy, subsisting pa yung marriage niya. Kailangan ng judicial declaration of nullity muna bago ka ng second. So, yup. Family code. Okay. A allegedly sold to B a parcel of land which A later also sold to X. B brought a civil action for nullification of the second sale and asked that the sale made by A in his favor be declared valid. Ulit? Sold B a parcel of land which A later... Okay. A, B, X. A sold to B. A also sold to X. May double sale. B brought civil action for nullification of second sale and asked the sale made by A in his favor declared valid. A theorized that he never sold the property to B, and his purported signatures appearing in his first name forgeries. Thereafter, information for estafa filed against A based on the same double sale that was the subject of civil action. A filed motion for suspension. Nauna yung civil dito. Okay, so hindi siya pala sa previous question. Nauna yung civil, saka nagkaroon ng criminal. Containing that, the resolution would necessarily be determinative is the suspension of criminal action in order. Yeah. Okay, natuto na tayo sa previous question. So, nauna na yung civil action dito. So, pwedeng i-suspend. Yup. Kasi, ba't kailangan? Dahil, i-determine muna kung may sale nga. Yeah. The suspension of criminal action is in order because the defense of A in civil action that he never sold the property to B and that his purported signatures in the first deed of sale were forgeries is a prejudicial question. The resolution of which, in a sense, if the first sale is null and void, there would be no double sale and A would be innocent of the offense of estafa. Okay. Yup. So, yun. So, yun lang yung bar quiz natin for 111. We're done. Okay. So, ayun. Happy aral. And, I hope that you're learning from this study with me sesh. Even if, maraming, yeah. So, yeah, bye. Good luck.